The Ontario Court of Appeal held that the trial judge erred in his interpretation of Section 566 of the Canada Shipping Act. The Court of Appeal noted that the section merely provided for joint and several liability where there were joint tort fees and did not impose liability where none otherwise existed. The Court of Appeal then considered other sections of the Canada Shipping Act also referred to by the trial judge but held that neither individually or nor collectively did they impose a statutory liability on the owner of the boat. The Court of Appeal did, however, confirm that an owner could be liable on the principle of respondent superior or on the basis of ordinary principles of tort law. In result, the Court of Appeal returned the case to the trial division for a new trial on the issue of the owner's liability.
Limitation and liability on oil pollution. Modern shipping industry has been plagued by oil pollution since the development of specialized vessels and then increase the cargo carrying capacity of these vessels. Depending on the vessel type, a number of possible sources of oil pollution can be identified on a board of vessels. Although marine accidents are the major source of oil pollution, they can also be a result of onboard operation and day-to-day activities like a tank cleaning or bilge oil separation. The International Maritime Organization, or the IMO, has developed an international convention for the prevention of pollution from ships. This convention formulates to include regulations for minimizing pollution from ships, both accidental and from day-to-day operations. The liability of damage resulting from a deliberate or non-deliberate oil pollution incident lies with the owner of the vessels, and hence a number of regulatory frameworks are in place to check the owner's inefficiency, to provide standard equipment and mandatory training to the crew to avoid such incidents. The owner is also expected to ensure himself against damage caused by a pollution incident and form an integral part of these regulatory frameworks. Oil pollution is a sensitive topic and has been tackled for 2 decades now. The efforts of international organizations and the member of states have led to a steep decline in oil pollution incidents. However, the responsibility lies with the owner and the crew on board of a vessel to keep such incidents in check and make shipping cleaning and sustainable for the future.
The result of the split is that the Ninth Circuit's ruling on Exxon's respondent superior liability for Hazelwood's conduct remains since Hazelwood acted in a managerial capacity under the Restatement Second of Torts Section 909 approach to punitive damages. After considering the punitive damage policies of foreign nations, the court reasoned that although punitive damage were warranted, they may not exceed what Exxon already paid to compensate victims for economic losses, which was about US $500 million. It held that a 1-to-1 ratio between punitive and compensatory damage was a fair upper limit in maritime cases that involve recklessness compared to the lower liability of negligence or the higher liability of intentional conduct. Of this reasoning, Boston University law professor Kate Hilton said, the court's elaborate and lengthy argument for the 1-to-1 ratio is troubling for several reasons. First, the whole discussion was largely unnecessary if the court really wanted to limit its decision to maritime cases. The court's majority appeared to be trying to make the case for imposing the 1-to-1 ratio as a default rule in ordinary civil cases.